So, the first topic I would like to talk to you all about is a bit of a niche issue here, but I actually think it's really important for you to know about. And it's important that this news isn't buried. And I'm not saying that anyone's burying it in particular, it's very much out in the open. But it's one of those pieces of news that you don't always hear a lot about unless you're in very specific circles. So, what am I talking about? There are two Supreme Court cases that I want to bring to your attention. One has already been decided, and one is coming up. So the first U.S. Supreme Court case I want to bring to your attention is called Van Buren versus United States. And this is a criminal case against an individual named Van Buren, who was a police officer who used a computer that he had access to look up something for personal benefit. So I'm sure many of you are aware that one of the issues with the with the NSA is that it was doing bulk data collection, but also more than that, people were using their access to these bulk data systems to look up ex-lovers, to spy on people that they were jealous of, and things like that. There were rampant amount of abuse. So Congress has passed this law called the CFAA, the Computer Fraud and Abuse Act. And essentially, this law doles out criminal penalties for individuals and organizations that misuse their access to databases. There are two words specifically, there are two clauses specifically that the Supreme Court is going to be looking at in these two cases. The first clause is excessive access to. And the second clause, although I'm forgetting the exact wording of it, has to do with the scraping of information. As in, what are you allowed to take from what is in theory publicly available information? Okay? So in Van Buren versus the United States, this police officer he has access to a database about lots of individuals with lots of personal information in it, and he uses his access in order to facilitate a personal search of some kind. So he was charged under the Act. And as the case worked its way up to the Supreme Court, essentially the last ruling before the Supreme Court touched it was, hey, this is a violation, clearly him using his police access, his professional access to this database for a personal lookup is clearly a violation of the law and clearly meets the grounds of excessive use. Straightforward, right? Apparently not so much. So this case ends up going to the Supreme Court, and our lovely right-wing majority on the Supreme Court, please note the sarcasm there, it decided 6-3 that actually a cop using their access to a public system in order to make a personal lookup is not a violation of the CFAA and is not excessive access. So I want you to pause and think about that for a second, what the implications are for you. Before I move to the next case, this is so important. You or I or anyone else appears in multiple databases. Some of them are even law enforcement databases, right? Whether you've got a speeding ticket or you got thrown out of a club or whatever may have happened to you, right? There's a good chance that all of us are in some registry somewhere. We ran a red light, we got a speeding ticket, we parked illegally, right? We end up in these databases. And a lot of information goes into these databases, including personal information like your name, your address, your birthday, sometimes even more sensitive information about you. So that's really worrying, right? That all this information is floating out there. But we are supposed to be comforted by the fact that these people who access these databases are professionals. They wouldn't use their access for personal grievances, would they? Well, that's kind of the fairy tale that we're all told. But we know from the NSA leaks that that Edward Snowden gave us that this is what happens. That there are huge abuses of the access to these data systems. So what this means is that any database that you appear in, for whatever reason, as long as the individual is allowed access to that database as part of their job, that means they can just look you up for no reason. A judge doesn't have to approve it. A supervisor doesn't have to approve it. They don't even have to be on the clock. As long as they can access this database, essentially what happens is you become the target of unwarranted spying. And what if this person is looking for bad reasons? What if they want to do harm to you? Your name and address are on there, right? The car you drive, the type of home, maybe even the amount of other information, family details, where you work, where you go to your house of worship, right? There are so many things that could possibly be in this that people could put together, and they could do harm to you. And even if they're not doing harm to you, they can be violating your privacy on a huge level. So clearly, we need better privacy protections, at least in this sphere, because this type of abuse should be punishable. You should not be allowed to abuse your work resources for your personal vendettas or gripes or what have you. And by the way, this is especially true if you're in law enforcement, because you are supposed to be responsible to the people, to regular everyday Joe and Janes, that we pay you, right? The whole purpose about law enforcement is that we pay them. You're supposed to protect and serve us. And of course, law enforcement, as I've discussed many times on this show, has lots of other issues with it. But this just adds to the level of the level that law enforcement tramples on our freedoms. This is supposed to be a key thing that the Fourth Amendment was supposed to protect against: unlawful search and seizure. And anytime someone abuses their access to a database where you have personal information, that is a search. And what they do with that information, who knows? Because no one's monitoring it. There's no secondary controls that allow for someone to stop it. Now, luckily, this cop got caught. I don't really know how, but I imagine that this is also happening in areas where people aren't getting caught, and that's really nerve-wracking. There's really no excuse for this kind of, there's really no excuse for this kind of behavior, and if it's difficult to trace, then that makes it even worse. So the solution, obviously, here is for the federal government to pass some sort of amendment to the CFAA that clarifies the meaning of excessive access and allows it to cover incidents like this. The Supreme Court, for its sake, said that, oh, well, if you made this type of searching illegal, then plenty of people who do not so naughty things with it will get swept up. I don't really buy that argument. I don't think lots of people out there are just casually abusing databases that they get access to for work, for their personal, for personal things. Maybe I'm wrong about that, but I really don't think that's the case. So that's our first case, Van Buren versus United States. Then there's our second case, which is LinkedIn versus hiQ. And that's, if you want to look it up, you know how LinkedIn is spelled, capital L, capital I, but hiQ is H-I, they're both lowercase, and then the letter Q, which is capital, okay? This is not a, I'm not throwing out to Q on people here. It's just the way the company's spelled. And in this case that LinkedIn is trying to get before the Supreme Court, LinkedIn claims that this company, hiQ, is essentially a data trawler. So what does that mean? So essentially, it takes information that's kind of sort of publicly information, like information you publish on your social media, specifically LinkedIn, and it uses it to sell you services. Well, so is this that different than other cookie services? Yeah, it is, because when you signed up for LinkedIn, the expectation was that this information would be public to other LinkedIn users. And of course, you have the ability to change the privacy settings in your individual LinkedIn page. But essentially, what hiQ is doing is they are just going through and taking as much information as can, collecting as much personal information that you're willing to put out there as you can for their own purposes that you didn't consent to. In many other countries, including in European countries, this kind of secondary use of data is actually already illegal, because the requirement is that in order for your data to be used by anyone for any purpose, you have to give a very specific consent for it. Now, different privacy laws in the US are coming up that will start to address this problem. However, once again, we are stuck relying in this particular case on the CFAA because this is kind of large batch scraping of personal information that this company is doing. Now, for hiQ's part, they say that they've actually been doing this for a very long time and it's never been an issue, except now LinkedIn wants to offer a very similar service and they're suing hiQ in order to kick them out of the market for this particular thing. Whether that's true or not, it actually doesn't really matter. So when this case goes up to the Supreme Court, it's true that the court will make some level of decisions about whether what hiQ is doing is illegal or not, but there's a more pernicious factor in here, which is we still have incredible issues with data privacy. Whether the Supreme Court decides yay or nay on this is illegal under CFAA, the fact that there are organizations that have been trawling our data for long amounts of time without our consent is still problematic. California and many other states have moved forward with comprehensive privacy laws, which would at least help a little bit with this problem. Unfortunately, what ends up happening is this law creates a patchwork. So it's become, first of all, for corporations, who I don't typically have sympathy for, but I will say, in the effort to protect our data against themselves and to not be struck with fines, it becomes very difficult for companies to comply with these kind of variable agreements, especially when multiple states have very different and sometimes conflicting ways of protecting data. So as we move forward, the obvious solution here is for the federal government to act and to create more privacy through privacy laws, and more specifically, to amend the CFAA if they don't pass a regular privacy law, amend the CFAA to make it so that this kind of trawling is illegal. But hopefully, I've been able to illustrate that these two Supreme Court cases are really important to you. And if you can, do give them a look up and a read. It's really fascinating to see kind of what the arguments are on both sides for and against this very specific type of usage of data. And it makes you wonder why it is that we're not able to get some form of privacy protection. Many of you may remember the Experian breach, the Equifax breach, I mean, where millions and millions of records were just lost. And many organizations that you invest in, and probably that you trust as well, have had large-scale data breaches. But oftentimes, these companies are barely fined. Executives don't go to jail. And a lot of the time, real people lose out. Once your identity is out there, pretty much anything can be done with it. Profiles can be set up in your name. People can pretend to be you. And either they can do things that will directly harm you, or they can just make it harder for you, the individual, to do anything unless, say, you pay them. Or you buy some other service to protect your identity. But oftentimes, once your personal information is out there, unless you have the ability to change that personal information, and by the way, for much of our personal information, it is either difficult or impossible to change. Think things like your home address, your social security number, or if you're rushing from another country, your national health or other national identity number. And other types of things, the type of car you drive, what you look like. This kind of information is all important to us. It helps identify us. It's called personally identifiable information. And in the United States, we really do not take a lot of effort to protect this kind of information. In fact, I have another story right after this one that I'm going to talk additionally about different types of surveillance that is done on Americans and on people all around the world. But just to come back and to close this story out, these two Supreme Court cases, Van Buren versus the United States and LinkedIn versus hiQ, are important for regular people to think about when they go to the ballot box, because essentially there are lots of issues going on. I totally get that. And many of those issues may feel much more pressing than a privacy issue. Well, who cares if they have my name piece of information here? It's not like they can do anything with it. But that's wrong. They can do something with it. And the things that they can do with it can really hurt you. We have the ability to protect this information, to hold corporations accountable, but we can't do that unless the lawmakers that we are constantly talking to or electing are on the same page here. So it is my hope that if you don't take anything else away from this segment, you at least remember that we need more privacy protections in this country, whether we pass a nationwide separate privacy bill or we just update the CFAA. We need to take a stand to improve our privacy in this country. And if we don't, who knows how many people are going to be affected by the pernicious effects of identity theft and other such mimicry before we before we are able to solve this problem.